The government watchdog group Citizens for Responsibility and Ethics in Washington, commonly known as CREW, has filed a lawsuit to bar former President Trump from appearing on presidential ballots in Colorado. The case claims that Trump should be disqualified from running due to Section 3 of the 14th Amendment. It's a post-Civil War provision that bans insurrectionists from holding public office. Laurence Tribe joins us now with more. He's a law professor at Harvard Law School. Professor Tribe, thanks so much for being here.
Thank you, Nancy, for having me.
Absolutely. Now, part of the reason that this has emerged into the public consciousness is because of an article that you co-wrote about the 14th Amendment this summer. And so I'm so glad you're here to help us break it down and understand it, because while it was something that was being discussed in Democratic circles and some conservative circles as well, now there are lawsuits and there are secretaries of state in states across the country saying this is an issue. So it's clearly here to stay. So help us understand exactly what the 14th Amendment says and why you believe that it may disqualify the former president from office.
I'm glad to do so, Nancy. I co-wrote that article with a very conservative, distinguished former federal judge, Judge Michael Luttig. We concluded, as have all the scholars who have seriously studied this issue, that the language of the 14th Amendment means exactly what it says. It says that anyone who takes an oath to protect the American Constitution and holds office and then engages in an insurrection against the Constitution or gives it aid and comfort can never again hold office in the United States. That language is unambiguous. It's clear. Whether it applies to Donald Trump will have to be decided by states like Colorado. And when they decide, then the U.S. Supreme Court will almost certainly have the final word, and it will come quickly. The reason we believe that this language applies, apart from all the facts we know about, is that it was put in the Constitution at a time when everyone realized that the executive branch would be unlikely to get convictions against former insurrectionists, because the president at the time was Andrew Johnson, who wanted to dismantle the Union victory in the Civil War. But it was going to be a permanent provision, a permanent protection against turncoats, people who turned against the country. If they weren't prosecuted, or if they were acquitted rather than convicted, or if they were pardoned, it wouldn't make any difference, because an independent determination would be made that they were disqualified. This lawsuit, brought in Colorado by Citizens for Responsible Ethics in Washington, representing 6 Colorado voters who clearly have standing to bring the suit, is the strongest of many around the country. It's brilliantly researched, thoroughly developed. The president is clearly frightened of it because he made a motion today, a frivolous motion, to take it to federal court, where he obviously hopes to get it dismissed. He's scared of this suit, and he should be, because it is.
He just said today, in fact, he was doing a radio interview. He called it a trick that amounts to election interference. And, there is a question about whose decision it is, who gets to decide whether he meets this standard or not, especially because he has not formally been charged with inciting an insurrection. He's been charged with a lot of things, but not that. And he certainly hasn't been convicted of anything yet. And I hear what you're saying about convictions not necessarily being a bar that has to be met. But if there are no convictions, who is it that decides at the end of the day that the Republican frontrunner should be barred from serving as president?
Well, in the first instance, secretaries of state have to decide. Whichever way they go, whether they say that maybe he's an insurrectionist, but we want it to be left to the people, even though the Constitution says that they are disqualified, the same way that, Barack Obama or George W. Bush or, Bill Clinton, they might all be very popular but they can't run because they're disqualified, having been president twice. This guy might be disqualified because he tried to overturn the very Constitution he pledged to protect. When it's decided one way or the other by secretaries of state, that will go up to the US Supreme Court. They will be in quite a pickle because a majority of them, I think, are, either beholden to him or quite right leaning, but they are also pledged to uphold the Constitution. If they decide that he is eligible to run, they'll have to explain why. And we'll all be interested in hearing that explanation, given the clear language of the 14th Amendment.
We certainly will be interested, and I think we're going to be talking about this a lot more over the next year. So, Tribe, I really appreciate you coming on and breaking it down for us.
Thank you, Nancy.